Swayam Prabha. Digital India. Educated India.
Namaskar friends, my name is Dr. Parikshit Sirohi and I am Assistant Professor, Senior Scale in Faculty of Law, University of Delhi. I would now want to welcome all of you to this, which is the third chapter, the third module of my course on cyber crime. So friends, these are the topics that we are going to be covering. First, what kind of restrictions are imposed by different nations on free speech. So we are the topic for this particular lecture is censoring the cyberspace. How the cyberspace is restricted, what kind of restrictions are there on content, on speech, on the internet in cyberspace. So friends, how are the nations restraining the domestic speech? What is the provisions regarding defamation? You have had a little bit of an overview in the previous sessions. How is pornography contained? How is subversive information contained? Hate speech, how is that tackled? What are the restrictions when it comes to privacy protection? What about obscenity and other related areas like child prostitution, subversive advocacy? There are some people who will advocate for the subversive elements. How are those tackled? How are those kinds of contents tackled? There will be certain limitations, as we have seen previously. The internet does not respect geographical boundaries, and hence there will be certain restrictions on national law enforcement as long as the cyberspace, as far as the cyberspace is concerned. So there is a need to develop some kind of an international regulatory norm. We may have already heard of just cogence in our study of international law. Can just cogence be applied in this regard as a tool? We are going to be looking at that. And then finally, what is the road ahead? How can we, what is the road to tackle the cyberspace? Because one thing is clear, the individual countries, when they are trying to tackle the restrictions or impose censorship on their own, they can only succeed to a certain extent, because the bulk of cyberspace is maybe outside that particular country. So cyberspace, cyber law does not really restrict the flow of information. So the task becomes even more onerous. Friends, as we know, the internet is having a very large amount of information. It is by and large completely unregulated. It is free of any kinds of regulation. It does not respect the political or geographical boundaries. These boundaries become absolutely irrelevant. They are of no importance. So you may be imposing certain restrictions on content in Bangladesh, but it may be freely available in India. You may be imposing some restrictions in USA, but then maybe in England you can see the content freely. So the internet actually needs its own laws, specific institutions. So which cannot by definition be country specific, friends. There is a inherent limitation on the national laws, because national laws will only succeed up to a particular point. So on internet based communication, there is an inherent limitation, because every nation has a definition of what the national interest is and what is the civic virtue. For example, in Thailand, if you are criticizing understand, both in Thailand and in USA and in India and even in China, of course just a sham, facade, they don't really believe in any kind of free speech, but both US and Thailand, and for that matter India, they have free speech. But in US you can freely criticize the president and his policies, no problem. In Thailand, you cannot say a single word against the king of Thailand. it will immediately land you into very serious legal trouble. So what I am trying to say is every nation has a definition of what is national interest and what is their civic values which they wish to nurture. The offending speech, the speech which the nations are trying to curb, is technologically dispersed immediately to millions of followers, to millions of recipients in a matter of minutes. So the speed and this one is speed and one is size of the populace. These are important aspects due to which it is very important to ensure that the speech is actually restricted and there is a uniform mechanism for restricting the free speech in case it is deemed necessary to do so. Friends, there may be certain free speech advocates, there may be cyberspace participants who want to have free trade in ideas. There is nothing wrong with that. So, in every aspect in life, there will be multiple views. So, here also there are two streams of argument. One says that no country has a right to curb the expression of ideas and speech on cyberspace. No matter how ridiculous it may be, it should be allowed to be voiced. And the other viewpoint, which seems to be now the dominant viewpoint, is you please analyze the number of ways in which the existing laws affect the rights of internet users. Friends, one thing is very clear, like in all aspects of life, we are walking on the road, we may be somebody may be wanting to play music, somebody may be wanting to study, somebody may be wanting to sleep. So you are wanting to balance the interest of different sections of society. That is what law is. Law aims to balance the interest of different sections of society. So similarly, regulation is inevitable. In cyberspace, there should be free dissemination of ideas, yes, but at the same time, illegal activities, immoral activities, pornography, obscenity, these serve no useful purpose and they must be regulated. So, whether you like it or not, friends, regulation is absolutely inevitable. It is going to happen. Friends, how do nations restrict the free speech? Now, different nations, depending on their ideologies, depending upon their thought process, they have various ways in which the free speech is restricted. The proponents of free speech, they think of internet as some kind of anarchy, completely unregulated, completely chaotic, no form of government interference. Government regulation is unwarranted, not needed. These people who propose the independence of cyberspace, they argue that internet is the only medium in the world, most democratic. It provides access to share views. It is a place which government should not disturb because it provides the unfettered and most democratic forum in the world. Absolutely right. But can there be any place where there is no regulation? Every aspect, every sphere of life. Now, if you are doing pocha in your house, can you be allowed to throw the dirty water from the balcony on the fellow whose house is downstairs or on the fellow who is walking on the road? You have a right to dispose of the pocha water wherever you want, but that doesn't mean that you can do it on the road. So, every aspect of life, some kind of regulation is warranted, is required, friends. So, countries who have not adopted the view that there are countries who have completely policed the internet. For example, China, North Korea, they will completely police the internet. But by and large, there are the countries of the world accept that, look, internet should be a free medium, and according to their own ideology, according to their own restrictions, they have provided the certain restrictions on the activities, speech, content that is taking place on the internet. So, we are going to be studying certain things that have been done by different countries, and this chapter is more of an exercise of comparative study of what is happening in different jurisdictions with regards to the various parameters that I have talked about here. So, these parameters, how the different countries of the world are tackling them, that is the purpose of this particular lecture. So, friends, the countries have not adopted the view that internet majority, almost all countries have not really accepted the view that internet can go on blindly without any kinds of protection. So, if you study various restrictions that various countries have imposed, you will see that these restrictions have been imposed by these countries based on their values, based on their beliefs, based on what they think is the things that need to be protected. So, regulation of free speech is absolutely inevitable. Regulation of cyberspace is inevitable because everything in the world has to be regulated. And therefore, it is required, it is in the best interest of internet users, free speech activists, that they should put aside their, it's a state of mind that no, we should not be regulated. Maybe regulation is in your own interest. So, the emphasis should be to develop the technologies which are minimally invasive, minimally restrictive. Not everything is being restricted, and at the same time, it should be absolutely effective and to restrict the free speech wherever it is required, friends. So, friends, the first part is libel. So, some other terms like defamation, slander, you have already studied in your law of torts and in your criminal law class. In my previous class, I have dealt with internet defamation in a significant degree of detail. So, friends, most nations today have some kind of law which is dealing with a speech that denigrates or spoils the reputation of another man. Many national laws apply directly to internet communication. Friends, this is a very interesting case which took place in England a few years back. On this Usenet bulletin board service, certain lecturers, certain persons had written stuff which was not entirely complimentary about the professional work, the professional competence of a nuclear physicist and another physics lecturer. So, both these persons, the physics lecturer and the nuclear physicist, they filed separate cases, and by these cases they sued those persons who had written the defamatory content about them on the internet bulletin board, and they got the suitable order from the court in England. So, these are the cases which have taken place just few years ago, friends. So what I am trying to say here is that libel, defamation, slander, that will definitely and can and will be protected across jurisdictions by countries by making their own laws. Friends, the next aspect is pornography. Now, pornography is, people may argue that it is, what one person considers good, another person may not consider good, and vice versa. Law is, the court should be concerned with law, not with morality. Pornography, what is the problem with it if it is immoral? Friends, that case does not stop over there. Pornography is not only immoral, but it is also illegal. If you are ever going to a website which is having the sexual content, they always ask you to check a box which says I am above 18 years age. Above 18 they are asking you to check. So, does that mean that above 18 any kind of pornography can be shown or any kind of pornography can be accessed? The answer is no, friends. So, different countries make laws according to their own moral standards. So, now morality varies differently from culture to culture, from country to country. In Islamic countries, Saudi Arabia, Iran, etc., handshakes with people of the opposite gender are absolutely impossible. It is unheard of. You cannot have a handshake even with your own wife in public. Even with your own cousin in public. It is not allowed. It is not acceptable. Whereas in France, you can go and publicly kiss anybody of the opposite gender when you meet them, when you hug them. So, it is a different question of cultures, and this different question of cultures is also manifest in different laws. So, friends, this Penthouse magazine, which is which shows which is a lot of adult content. So, it's a pornographic magazine. They have a website which shows that 25 countries of the world, including India, Egypt, Japan, Spain, South Korea. So, when I say Korea, I mean South Korea, because North Korea nobody is really concerned about, there is always a permanent embargo. UK, Mexico, they have outlawed their adult material, and they say very clearly on the website that if you are living in these countries, please do not come and access the material on our website because it is going to be illegal. So, under our previous IPC, it used to be 292 accessing such material. There is a provision under the Information Technology Act as well, but IPC says 292. Under the BNS, Bharatiya Nyaya Sanhita, it is 294 is the relevant section, which says that such activities, pornography, is not allowed by law as per the main penal law of the country. Friends, there is the Obscene Publications Act in England, which defines obscene as material which may corrupt or deprave the persons. So, such material is obviously not going to be desirable to have such material. So, that is why they really do not want you to access such material. See, now I told you that look at these countries, the Saudi Arabia, Iran, etc. Any kind of religion discussion, any kind of discussion on sex, any kind of discussion on politics, not allowed. So, you can discuss politics freely in India. You may even to some extent be allowed to discuss religion freely in India, but sex, no. In the sense that if it is about pornography, etc., no, not allowed as per Indian law. This is the provision in IPC and this is the provision in BNS. So, similarly, Germany, they had this very infamous case of this popular company called CompuServe, and after that the laws which were previously already there to protect children the enforcement was greatly enhanced to protect children from the ill effects of pornography and child pornography. Singapore has implemented a licensing scheme for all internet service providers, all content providers, so that the sexual excesses on the internet can be regulated. So, friends, as you can see, the scattering of countries across the world, England, then 25 countries, then 3 Islamic countries examples, then Germany what they are doing, Singapore what they are doing, Australia I could give you examples, US. So, they all have certain restrictions with regards to pornography. There is a great argument that porn industry is a legal industry and porn industry is using free speech. No, that is not allowed, friends. At least in India there are strict rules on that. Friends, similarly you have subversive information. Now, because of the speed by which information can be disseminated, because of the size of the audience both in India and abroad that can be reached in 1 minute through the internet, the potential for harm is immense. So, there are various dissatisfied groups, there are various splinter groups in every organization, in every form of government, everywhere, every society, every country. So, they will be always trying to foster disaffection against the government. Now, today this is becoming a concern because previously they would make phone calls, they will visit, they will distribute pamphlets. So, their reach is very limited. But because of the wide reach of the internet, ability to reach large number of people, not only in India but all over the world, means that the potential for harm has greatly increased. And recently we have seen countries like Italy and England have seized computer devices, equipment of anarchist groups. These are the groups which are advocating anti-government violence. Now, anti-government violence, you may say that the government is very bad, you may say overthrow the government, but to say that kill the people who are in the government, you burn the government machinery, that is inciting violence which can never be allowed in any government, in any kind of jurisdiction, irrespective of how much tolerant people may be of democracy and democratic protest, friends. So, again, Vietnam is a communist country and they are concerned that the more communication, more links with anti-communist nations, non-communist nations could actually undermine the ruling regime. So, therefore, they have tried to control the internet access. Friends, the next problem is hate speech. Now, what is hate speech to one person may be hate speech to not hate speech to somebody else. Somebody may be wanting to have a very different view on people belonging to one particular religious denomination, one particular kind of organization, one particular religion, one particular ethnicity. We have seen time and again what damage hate speech can do. It has led to the partition of the country in India. It has led to bloodshed all over the world. It has led to the Holocaust, wherein millions of Jews were really badly exterminated and attempts were made to remove them completely from the face of the earth. So, hate speech is so because the Holocaust took place in Europe, so the countries which were most affected by the Holocaust, Germany itself, Austria, France, you will find that these countries have some of the strongest, most virulent laws which are criminalizing hate speech, because these countries have been badly scarred by the Holocaust. So, in Germany, there are many provisions which are directed at expression which is inconsistent with the degree of dignity that is required for every human personality. Every human being, man, woman, child, adult, requires some amount of dignity. Otherwise, he or she will not be able to develop freely within the social community. So, Germany, they have made many provisions in the law. They are very strict about laws outlawing the hate speech, Nazi propaganda, and there is now considerable debate whether Nazi propaganda, because Nazi sympathizers have really reduced in number over the last 70-80 years. How much is the need to include the laws should be concerned with Nazi propaganda as hate speech? Does it really matter enough? So, there is now a debate in Germany, but so far they have been very strict on anti-Nazi propaganda. So, Austria, again, there is the Austria Prohibition Act, which prohibits actions on behalf of Nazi party, advocacy of Nazi party, symbols and propaganda of Nazi party. France, again, friends, has very strict laws against display of Nazi symbols. The Nazi symbol is swastika. If I were to make this in France, I would go to jail, friends. This kind of a symbol cannot be made in France, because they have again been one of the sufferers of Nazi propaganda. Canada criminalizes willful promotion of hatred, communication of messages on telephone which are likely to expose people to any kind of hatred based on race, ethnicity, color or religion. Friends, there is this case of Lycra versus Yahoo, which comes from France, which I want to talk to you about in this context of hate speech, as well as in the overall context of jurisdiction on the internet. You will be able to understand how difficult it is to regulate the hate speech and how difficult it is to have the content on the internet. So, friends, there is one particular organization called Lycra, and they were having an auction of certain Nazi memorabilia. They were having an auction, and in that auction various things had been put up, including certain Nazi memorabilia. Say, for the example, this swastika symbol, a cup which has this swastika symbol, or a blazer which has this symbol. Various such Nazi memorabilia was up for sale. Now, French law says that none of this can be put up on display in France. Now, this website was headquartered on the Yahoo domain, and this website was on an American company. So, the French government asked the Yahoo company to remove this page, this auction, and make it in such a manner that these Nazi symbols, these Nazi memorabilia could not be seen by any user of the internet sitting in France. Any person who is accessing the internet from France should not have access, should not be able to see this Nazi memorabilia. That is what the French government asked them to do. Yahoo says, look, we can't do this. Your laws don't apply to us. We are headquartered in California, USA. So, your laws don't apply to us. Sorry. And as it is, we can't, we are not amenable to your jurisdiction. So, the French government says, at the request of Lycra, who had brought the case, the French court directed the Yahoo company to block these pages in such a manner so that the people in France cannot see them. Upon refusal of Yahoo to do so, the French court ruled that the Yahoo must be blocked. So, this now how will that be done? These are the problems that arise in the jurisdiction issues of the internet. Now, the French court may give an order, but this order, how can you enforce it over the internet? It is often easier said than done, friends. Friends, as we are aware, under Article 21 of the Constitution of India, as per the judgment of Justice Retired Puttaswamy versus Union of India 2017, the right to privacy has been held to be a fundamental right under the Constitution of India. Now, previously in other jurisdictions like USA and UK, the privacy has been upheld to be a fundamental right. In India now, in August 2023, the Digital Personal Data Protection (DPDP) Act has been passed. It is called the DPDP Act. Digital Personal Data Protection Act has been passed, and friends, that is why there is a responsibility which is given to all the persons who are collecting the personal data, that data must be kept most secure, and if there is any breach of this data, the persons who are responsible for the breach, not only will they be responsible, but even the organization will also be responsible. So privacy protection is a very important aspect of the internet as we understand it today. So if somebody in the name of free speech is violating privacy, that is going to be a problem. People have argued that in India the Right to Information Act and the Personal Data Protection Act will come into conflict. No, that is not the case, because the Right to Information Act is not concerned with personal information. In fact, it has section 8, which itself says that personal information cannot be requested. And what is personal information? Age, name, marital status, what kinds of diseases you may have, what is your sexual orientation, what is your religion, what is your caste. These are things which are not supposed to be disclosed, personal data. So similarly, the section 78 of the Information Technology Act provides for the liability of the intermediary to safeguard the personal data. Like I mentioned, if there is any breach, then the intermediary would also be liable to give compensation to the person. In the European Union, the regulation is there about flow of information about individuals to prevent the intrusion of corporates into the life of the individuals. Also in the European Union, friends, the member states have actually agreed that they will not export the personal data of individuals to countries where the privacy standards are not good, where the privacy of the individual is not protected in a proper manner. The United States has always been a great champion of personal privacy. So, in fact, if you read the judgment of Puttaswamy, as I have pointed out, the judges, especially the present Chief Justice, who is one of the authors of the judgment, he has referred extensively to the American jurisprudence in this regard. And when they talk about privacy protection, they say that the regulation of speech done through the means of the US Supreme Court has identified various varieties of vulnerable expression. They are called low value speech. And the Supreme Court says they are low value speech, they are expressions that are not essential for any kind of exposition of ideas. They are great champions of free speech, but at the same time they are wanting to protect the person's privacy. So the two are not always, friends, going to be in conflict with each other. And what are the things that are low value speech? The intentional incitement. This is what the Supreme Court of United States included. The obscenity, the child pornography, the defamation, the fighting words. The fighting words are words which are not inherently menacing, but when they are taken in a particular context, the meaning changes, they become menacing. So tomorrow, if one person, Mr. A, were to say to Mr. B, I will kill you, maybe that word per se is not so menacing. It is. In India, in the IPC 506 offence is made out. But if there is already some kind of a fight between these two persons, and then Mr. A is saying to Mr. B, I will kill you, then it becomes a fighting word. It becomes even more menacing because the context is such, friends. So, friends, commercial speech, advertising, that is not going to come within the value of advertising can be restricted. In India also there is the case of Tata Press versus MTNL, wherein the advertising has been called free speech, but advertising can be restricted if there are certain circumstances. There are so many advertisements which have been restricted on various grounds, including violation of privacy in the US. Friends, even the most liberal, most democratic countries of the West that you will see, they have also consistently restricted the freedom of expression on various grounds, which we have discussed. Next, friends, we are moving to obscenity. Now, obscenity is not the same as pornography. Obscenity may be a subset of pornography. Again, obscenity depends on the time and place, friends. What may be perfectly okay in one particular sphere is absolutely inappropriate in another sphere. So, the Puttaswamy judgment, for example, talks about an intimate sphere, an intermediate sphere and a public sphere. You are expected to behave differently when you are traveling in Delhi Metro or Kanpur Metro. You are expected to have little more freedom of your own when you are in your drawing room of your house, which is your intermediate sphere. And when you are in your bedroom, you have a different expectation of privacy. So, that is why when you have a camera in the change room, that is serious violation of privacy. When you have a camera in a hotel room or a bathroom, there is serious violation of privacy, because there you are expected to be in your intimate sphere. You may be without clothes, you may be doing various activities which you do only in private. So, there is legitimate expectation of privacy there. But roaming around without clothes on the road, you do not have any privacy there. So, the same logic applies here also, friends, that the obscenity is a quintessential example of valueless expression. When I say quintessential example, means it is a classic, most basic example. It is absolutely bereft of any kind of communicative value. There is no need to communicate. If there is something obscene, there is no need to share it with anybody else. We get so many kinds of forwards on our phones on WhatsApp. Many of them may be obscene. Many of them may be coming from your school friends who have become adults now. But should we start circulating those and say this is free speech? No, they are completely bereft. There is no need to circulate them. And that is why they are always going to be subject to certain broad controls. Again, friends, the US Supreme Court, why I am quoting from US judgments, friends, because the US is the champion of free speech. The maximum protection that they have been giving to free speech, it is part of their constitution separately. It is part of our constitution also, 19(1)(a), but it is more explicitly mentioned in their constitution, free speech. So, in the case of Miller versus California, 1973, they have clearly distinguished the obscenity from free speech, and they are saying that obscenity is something more than distasteful, rough, evocative and erotic speech. So, we may tolerate speech or written content which is distasteful, which means bad, dirty. We may tolerate rough, which is poor language, which is rough content. We may even tolerate evocative, which is suggestive words. We may even tolerate erotic words, with some things dealing with sex and all of that. We may even tolerate that. But obscenity cannot be tolerated. So, they have differentiated in this judgment way back in 1973, and this holds the field even today, that obscenity is something other than distasteful, rough, evocative and erotic. This can be tolerated in the name of freedom of speech, but obscenity can never be tolerated, friends. So, this question comes to India also. Now, on the internet, can we have lewd songs, songs whose meanings are very suggestive, songs wherein people are behaving, the lyrics are such and the gestures are such that they are very, very bad. So, then if for all such matters, you can always refer to 292 and 294, 292 in the old IPC and 294 in the new BNS. So, the US Congress, friends, in 1996 has criminalized the internet dissemination of not only the obscene material, but also all sexually explicit text and images. So, when anybody is, so they have made a law in 1996 to prevent, to make it a crime to share on the internet any obscene material which is there, and not only obscene material, friends. Obscene material means text, but also all kinds of material which is sexually explicit, which contains images, which contains some kinds of sexually explicit text. So, under our law, section 67 IT Act punishes for obscenity, and like I said, 294 of the Bharatiya Nyaya Sanhita 2023, which has just been passed, friends, in December 2023, received the presidential assent. Friends, the next area where the internet can be censored or is being censored or should be censored is the case of subversive advocacy. Whenever there is an intentional incitement or subversive tendencies, this is the court tends to look at content based regulation. So, whenever the court is looking at content based regulations, so because this is a special case, this is you are not indulging in subversive activities yourself, but you are advocating subversive activities on behalf of somebody else. For example, Mr. A may be involved in subversive activities. You are not a colleague of Mr. A, but you are a sympathizer of Mr. A. You are writing in support of Mr. A maybe. So, when you are conducting such activities, the court will always tend to uphold the validity of the content based regulations. There is a general trend, friends, across the regulations to permit across the jurisdictions, across all countries, to permit the regulation of expression only if it is in consequence of such utterance wherein there is a genuine likelihood. Somebody has said something, and on the basis of that sentence, on the basis of that utterance, on the basis of those utterings, those words, there is a general likelihood that some kind of unlawful activities, some kinds of unlawful conduct will definitely happen. In such cases, in most jurisdictions, they will allow the regulation to take place. They will allow the censorship to take place. When I say regulation here, I mean censorship. Censorship of content, censorship of words, censorship of free speech. Friends, in the case of Brandenburg versus the state of Ohio, 1969, the Supreme Court of United States, Supreme Court, this is the Supreme Court. The Supreme Court of United States says that the First Amendment of the US Constitution protects advocacy of even the most alarming notions against direct criminal prohibition regardless of danger and intent. So, what does it say? It protects the advocacy of even the most alarming notions. They are even the most alarming suggestions which anybody is making, even that is going to be protected, provided there is no direct consequence that unlawful activities become absolutely imminent. So, this is what they have said in 1969. Even after more than 50 years, friends, this judgment is holding the field. Friends, when we talk about national enforcement of censorship, when we talk about censorship of the internet on a national basis, India censoring internet in India, France censoring internet in France, I just gave you the example of what happened in Lycra versus Yahoo. So, there are inherent limitations because geographical borders are not respected by the internet. The Indian court's orders cannot be executed by another court outside. In fact, in the previous session, we have learned that even in internet cases wherein you are getting a extradition, you can only try for that particular case which is mentioned in the decree. Otherwise, you can't even try for the other cases. Friends, cyberspace has radically undermined the relationship between online phenomena and physical location. A person may be committing a crime sitting in Spain, and the crime may take place in Bangladesh or India, or Bangladesh and India. So, for example, friends, the terrible incident which took place in Sri Lanka, wherein the places of worship were attacked, or the similar incident which took place in New Zealand, they were not plotted from New Zealand or Sri Lanka, they were plotted from many hundreds and thousands of kilometers away. Similarly, what happened in India, the series of blasts which happened in Jaipur and in Bangalore and in Hyderabad and Delhi, they were not taking place, the planning did not take place from India, friends. So, what is happening in India, the consequence may be taking place elsewhere. The relationship between what is taking place online and what is taking place at the physical location, that has drastically been altered with the advent of internet. And since internet is increasing, the rise of the internet is there, such links are being completely destroyed. The link between, so today, previously somebody committed a crime in India and he would have been sitting in another part of India maybe, or sitting in some part of the same city and committed that offense. But now that is not the case, and these links are becoming even more tenuous with the growth of the internet. So, friends, when I say local governments, I mean national governments. So, the power of the national government, the power of the local government to control such kind of overbearing behavior on the internet is extremely low now. The effects of online behavior is there on other aspects also. So students see students in other parts of the country or other parts of the world behaving in a particular manner, they also start behaving in the same manner. Whether it is good for them or whether it is not good for them, it is a completely entirely different thing. But internet influences other kinds of behavior also. So the legitimacy of the local government to regulate global phenomena, it becomes questionable, and the local government has to give the adequate notice of set of rules that govern the internet, and which again creates problems for law enforcement, friends. Friends, now that we have seen what are the limitations for national law enforcement, I think it becomes imperative to now have a look at what is the situation with regards to the international regulatory norms. How far can international regulatory norms help? Because see, the internet is not respecting your territorial boundaries. The global information infrastructure is there, and there is an ever increasing de jure regulation of free speech, but similarly there is an all pervasive de facto futility of enforcement. Why I use these words de jure and de facto? Because on the face of it, you will find more and more laws are being made in the countries to control, to regulate the content on the internet. So that is what de jure. You are the by legal position you are changing, you are making more and more laws, but unfortunately you are not succeeding in changing the situation on the ground, the de facto situation. So the enforcement becomes futile, and the quantity of the regulation that you are having on free speech in different countries is increasing all the time. So but the results are not there, friends. So this is actually a paradox which is there. The international dimension is actually both strengthening and at the same time weakening the regulation, because by harnessing, by using international cooperation, by harnessing the international infrastructure of other countries, the country can actually do better. The country can actually harness the internet and its strength in a better manner. So the other side is that with the growth of the internet, the regulation of free speech within the country, the ability to do so is going to only reduce. So what is happening across the world is that national legislatures, for example Parliament of India, they are continuing to make laws. They will continue to make laws, but such regulatory endeavors, such efforts by the legislature are unlikely to really be enforceable, because there is the desire is the internet is such that it cannot be policed by any particular country as such. Friends, the task of creation of a general principle and agreeing to such a principle internationally may become a very tough task. So first of all, creating a general principle, that is the need of the hour. At the same time, you create some kind of an international consensus on it internationally. That it is easier said than done, because you see, now all countries of the world are sovereign, and getting them to accept that there are certain things which they may not be able to do individually, they must cooperate with the other person, can be a tough task. Do you know, friends, terrorism has been impacting the world for more than 50 years now. There have been very serious acts of terrorism. The entire Olympic team of Israel was killed in 1972. Israel responded in one particular manner, going after the terrorists. We in our own country have been victims of terrorism for a very long period of time. The West was not exposed to terrorism until 9/11 happened, and 9/11 happened in 2001, which was the beginning of the 21st century. But even since 9/11, 23 years have elapsed. Since there have been terrorist activities undergoing in the world for more than 50 years. in the last 20 years, the Western countries, whether it is Spain, whether it is UK, whether it is France, whether it is New Zealand, whether it is Japan, they have all been victims of terrorism. So previously they thought only countries like India and Israel and Pakistan would be the victims of terrorism. But friends, even till today, there is no international definition of terrorism. So if there is no international definition of terrorism, friends, can there be a definition of a cyber terrorist? Cyber terrorism is only a branch of terrorism. So first of all, you have to agree on terrorism, a definition of terrorism. Only then can you agree on a definition of cyber terrorism. So similarly, this is the way forward, friends. But creating such kind of a general principle and getting people to come to some kind of a consensus, it is easier said than done, friends. So it is more advisable, in my view, to go in for something which is already existing, an international legal principle called jus cogens, which you have already studied when you were studying international law, friends. Jus cogens can be used as a basis for methodology where the entire regulatory framework of censorship of internet can actually be structured. So whenever you have this kind of a regulatory mechanism for censorship and based on jus cogens, that I think in my view can be a easier solution as compared to this task of setting a general principle, getting a consensus and getting the countries of the world to agree on it. Now friends, for those of you who have forgotten, here is what jus cogens means. Jus cogens is actually compelling law. It refers to a category of norms which govern customary international law. It is compelling law, which means you have to accept it, refers to category of norms that govern customary international law. In English, it is called a peremptory norm, not a peremptory law, a peremptory norm. So which has to be obeyed, it is a norm. This may very well provide the potential basis for regulating the free speech and other content on the internet. This is gleaned from verifiable behavior across the Committee of Nations, fulfills various methodological requisites and offers the potential for achieving necessary substantive consensus in the international arena when you are dealing with moderation or regulation of free speech. Friends, an approach based on this concept will help you to narrow the parameters for restrictions to the lowest common denominator. Different countries may have different expectations. A jus cogens based approach will help you to come to the lowest common denominator, and therefore the countries will be able to avoid the risk of having what is called cultural imperialism. Nobody will be able to say that, look, country A is foisting its cultural agenda, or we are being governed by the norms or the cultures of country A or country B or country C, because as we discussed in the beginning of this lecture, every country has very different culture and morality, and the norms vary according to the culture of the place. Friends, what is the road ahead? Policing the internet is easier said than done. There are tons and tons of pieces of information which come up on the internet every day. It may not be possible for any country on its own, any ISP, internet service provider on its own, to manually go through or use algorithms or use artificial intelligence to go through all the content which is available on the internet, which is being uploaded by people all over the world every day. So it may not be possible. So you may have to tackle this on a case by case approach. The ISP's liability must be very clear that the moment it is pointed out that certain content is there which should not be there, that content must be immediately removed without any kind of dimmer. all ISPs must immediately comply with the laws of that particular country. We have had cases in India wherein we have had a lot of difficulty in getting the internet service providers to comply with the laws of the land. The courts have been roped in, and the IT ministry has had to use very strong measures against very large intermediaries when to make them comply with the regulations and the law in India. So such situations should never be allowed to happen. The cases of G. Venkat Swamy, wherein this gentleman was a former textile minister of India, and somebody had posted defamatory content about a very senior politician in India, and he petitioned the internet service provider to remove it. They did not do so, and finally he had to go to the topmost court of the country and secured an order to remove it. Similar things have taken place wherein people have posted all kinds of, I would like to use the word nonsense, please pardon me, against our gods, against our most sacred gods, and obviously such things are going to hurt the sentiments of persons, and the internet service providers must immediately in such cases remove this kind of content. Such content cannot be allowed in the name of freedom of speech or cultural expression or anything like that. Our gods, our individuals, they cannot be defamed. So still people feel that regulation of internet is actually a national issue rather than an international issue. The international aspect of this information infrastructure places a very unique and unexpected constraint upon both the free speech advocates and the regulators. They are both given very onerous responsibilities because like we were discussing previously, these are hitherto uncharted territories. We are all learning. So the law in this regard, the framework in this regard is likely to change in the days to come. So only an international perspective, friends, because of the limitations of the national perspective, the national approach to tackling the speech on the internet, only an international perspective can actually overcome the short-sightedness of free speech absolutists on one hand and regulators on the other hand. Regulators want to police the internet and absolutists want complete freedom. So like in most other things in life, the truth is somewhere in between. The speech restrictions on the internet must be elevated to the international level because they will become easier to enforce. There should be some kind of understanding amongst nations. Just cogence is a good way to do so, and by doing so, it will also make it globally enforceable, friends. Just cogence embodies the global consensus, positively binds all nations, and therefore it could be a very useful tool, friends, to draft a possible solution to this particular problem of content on the internet. Because just as one man's terrorist is another man's freedom fighter, one man's speech may be really painful to another man. So we have to be mindful of these issues and ensure that the internet or users of the internet are not allowed to either indulge in defamation or libel or slander or pornography or any other such offense. So I hope you have enjoyed this lecture as much as I have enjoyed bringing it to you. Thank you very much.